SJC-12509, King versus Spofford et al.
Mr. Dombrowski, good morning.
Good morning. May it please the court, John Dombrowski, on behalf of Cindy King. This particular case presents an interesting procedural history and facts that I believe are largely not in dispute. The certain petitioners, recall petitioners, residents of the town of Townsend, had a recall petition certified by the Board of Registrars. Ms. King, who is serving as a selectman for the town of Townsend, filed a complaint in the Lowell Superior Court, along with a motion for a preliminary injunction. The trial court denied her motion for a preliminary injunction. She filed an appeal before the single justice of the appeals court, who reversed the trial court and instituted the preliminary injunction. The recall petitioners then did two things. They filed for emergency relief before a single justice of this court. That was denied. They also appealed to the full panel of the appeals court, the three-judge panel, who reversed.
I think we know the procedural posture of the case.
Okay.
Can I ask you a question? If it had only read as follows, the first paragraph of the affidavit, we, the undersigned voters of Townsend, do hereby demand that a recall election be initiated against Selectman Cindy King on the grounds of misfeasance and neglect in her role as selectman. If that had just read that way, would that have been okay?
I don't believe so, and I'll tell you why. The recall process is set in motion by a recall affidavit, signed statement. The underlying act in the affidavit is a statement of the grounds for recall. Right. The underlying act, unlike other municipalities, this particular underlying act specifically either defines or gives some general guidance to exactly what they mean by those particular terms. So to simply put them there without some substantiation would not be in compliance with the Townsend Recall Act.
I can't remember whether it's the appeals court case or our earlier decision. Didn't one of the cases just track the language without explanation? I think it was the appeals court case, right?
Well, there's two principal cases. There's Donahue versus the town of Saugus, and the Recall Act in Saugus, essentially you can recall an elected official for any reason whatsoever. In Michkowski, which involves the town of Hadley, that Recall Act lists specific grounds, but it doesn't give any definition. It doesn't give any explanatory language, nothing whatsoever. And our position, Ms. King's position, is that this particular act, the Townsend Act, differs markedly from those two cases. You have a situation where you have four grounds for recall, and you have very specific language following each of those grounds. And it's not ambiguous language as the appeals court suggests. It's very simple, very easy to follow language. And then it contains a proviso at the end, which essentially states that, just to summarize, we're not looking to recall people under any circumstances for discretionary functions, although it's cast in the vernacular of votes, but I'd suggest to the court that everything Board of Selectmen does is essentially a vote. They cannot bind the municipality individually. They're a Board of Selectmen, and they make a decision, and then that decision carries. It's not an individual decision in any manner.
What's your response to the argument that the description of the grounds, the description after each of the grounds is more of a example of what the grounds mean?
Well, I believe the appeals court calls it an inexhaustive list of examples, but my response is the language itself. The language is that specific that it almost can't be interpreted any way and make any sense. To say it's just an example is to ignore that language. I don't know how else to put it, but it's plain language, it's simple language. I'd remind the court that prior to 1995, Townsend did not have any recall act. So in 1995, they established there is a recall statute put into effect, and it lists the grounds for recall, and it tells you exactly what each of those grounds are.
Is there any legislative history that tells you what they actually meant, whether they meant it to be examples or meant it to be, this is what it means?
Not that I was able to, discover, except the plain language of the act itself. And I think that plain language, it almost cures the concern that is raised by the appeals court.
You don't quite do a plain language interpretation. When you interpret the last proviso about votes, you're asking us to go beyond the plain language, aren't you? These weren't the neglect of the misfeasance here that's alleged is not anything to do with voting.
Well, I'd answer that in two ways. I'd go back to my earlier position that virtually everything a Board of Selectmen does in their capacity as a selectman is essentially a vote. If you look at the grounds that are contained in the recall affidavit, they almost assuredly come from votes that were taken, decisions that were made. But I'd say that the appeals court, and my brothers fall into that same trap, they want the explanatory language or the definitions to be, well, those are just examples, we can interpret them any way we want, but then when we take that last sentence, well, now we're going to interpret that very strictly. I'd say, that the single justice decided not to make that hard decision, didn't feel he had to, but I think his decision was obviously, I think his decision was sound, and accomplished the intent of that particular statute. Again, the appeals court, what they want to do is they want to turn this recall process into a system where judicial review is merely ensuring that the local municipal board of registers added up the number of signatures correctly.
Your view, though, is that you take the recall affidavit and you compare it to the act, and it really doesn't matter if we're dealing in this situation with specifically defines the grounds or elaborates. The recall affidavit, you say either way is insufficient.
In this particular case, yes, the recall affidavit, the grounds contained in the recall affidavit are not remotely close to those grounds contained in the recall act itself.
If I can follow up on a question Justice Kafker asked earlier. In the absence of any legislation, there is no power to recall, correct?
I'm sorry.
The absence of legislation providing for recall, Townsend has no power to have a recall election, correct?
Correct, that's correct.
Townsend could have done what Saugus did, which essentially say you may recall on any grounds.
Yes,
And if that were what they did, am I correct that you would not be here?
I agree with you.
Okay, I guess, and Townsend could have done what Hadley did in the appeals court case and simply identified categories,
Yes,
which, you know, here, they identified categories, but they also identified rather specific provisions.
yes.
With the categories in italics under the original legislation, I gather?
There are, I've seen the document with parentheses, and I've seen it without.
I've seen both, too, but
Yes, so
it seems as if when I go back to the original Chapter 27, Section 2, I see italics. A meaning, what meaning do we give to the choice of those being in italics and the specifics grounds being in regular print?
I don't know if there's any significant meaning you can give to those, given this very specific language following each of the grounds. And not only specific language defining or explaining, but also circumstances where they then go on to further define, for example, repeated absences. They go on to qualify, but you know, if you're ill or some other reason that is contained in there, that's okay. But this is the act that Townsend adopted, and frankly, the plain meaning of the act controls the cases relied on by my brothers, by the appeals court, are easily distinguished.
Well, what do we make of our role in that Judge Green appropriately wrote that judicial review of the adequacy of the grounds is exceedingly narrow, that we're not to stick our nose into the grounds, basically, as long as there are appropriate grounds?
Well, exceedingly, as Judge Green said in his opinion of the single justice of the appeals court, you know, he recognizes that it's exceedingly narrow, but again, there's still a review. There's still a need for the recall affidavit to comply with the statute.
But you agree that we would have to accept the allegations in the affidavit as true?
Yes.
So we don't second guess them?
No.
We would say, and so you say we take them as true, and then we see whether or not those allegations accepted as true, given reasonable inferences, would fall within the grounds for a recall,
Yes.
much as we do for a motion to dismiss.
Yes, much as a town clerk does when they're setting a weekly agenda for the Board of Selectmen or the City Council. You know, does this agenda item, is this properly allowed on the agenda? It's done every day, and Townsend has made it very easy. These are very specific grounds. We don't need to guess as the appeals court wants us to guess, or as my brothers want us to guess. It's laid out there, and I just want the court to be reminded that Ms. King was elected at a general election, a regularly scheduled general election. And this decision thwarts that.
When's the next election?
Well, her next election is a year from April. There is they have 3 board members, and they have staggered, so they essentially have an election every year. So there is an election April 23rd, I believe, but I don't think there's enough time to publish so that if this honorable court thought that, my position was erroneous, that I don't think that this recall election could get put onto that particular election.
And what's the status of Mr. Clark? I understand that his term's up.
His term is up and he is not running for reelection, so I guess practically, but certainly not legally, this case is moot for him.
Can I just press you on just how precise it needs to be? So there's no give in your view, right? The only grounds are the exact ones in the parentheses or the italics, right?
I'd suggest that best case scenario, that is correct. Those are the precise grounds.
So I'm just trying to.
Or at a minimum, those grounds are furnishing, as Judge Green said, some guidance as to what this act means.
So is Judge Green's interpretation the better one in your view, or the precise grounds? Because I'm just testing the precise grounds for a second. So it says in sobriety while performing official functions. So, I mean, I take it that refers to being drunk. I mean, if you were addicted to drugs, would that not meet the definition? And let me keep going. So corruption, say you were convicted of murder, would that not meet the definition? I'm just trying to get a sense of how, is Judge Green right that we look at these as sort of like, so there is some give in these, or is it just precise?
I tend to think that Judge Green's interpretation probably balances the equities of what this act is trying to do more liberally and perhaps more fairly for all sides. If the court's concern is the appeals court's concern, which is, are we going to be over-policing this thing? How much is the judiciary going to stick their nose in it? Well, the easy answer is we just follow what Townsend says because, it's very precise. It's almost error-proof. But to decide the way the appeals court did decide, and to decide the way my brothers want you to decide, is to essentially ignore the express language of the act, which isn't fair to anybody. I see my time.
Yes, thank you.
Thank you.
Mr. Selesnik, good morning.
Good morning, Your Honor. Ira Zalesnik for Joseph Shank, Elaine Shank, and the other 8 citizens of Townsend who were named as defendants in this action. I would suggest to the court that the issue before the court is one of statutory interpretation, it being the Special Act, Chapter 27 of the Acts of 1995, as the Chief Justice pointed out. There is no constitutional provision for a recall election, and the right to a recall election is a creature of statute. And so we are left here with a question of statutory interpretation as to how the Townsend statute ought to be interpreted. But I would suggest that that interpretation must be made in light of the purpose and effect and reason for having recall elections in the Commonwealth. And in both the decision of this court in the Saugus case and the decision of the appeals court in the Hadley case both showed that the recall process is supposed to be a fairly quick, efficient, precise process. You gather the signatures, you present them. If they're certified, you proceed to hold the recall election, and it's up to the voters to determine whether or not the grounds for recall are appropriate.
Isn't that
if-
asking us to ignore the language in the statute? You know, and I understand that, how do we get past what the language of the statute is?
It's
Aren't you
it's not
reading
getting
in-
past it, Your Honor. I would suggest the only statutory interpretation of the act that gives effect to all of the language without eliminating terms and doing other things that are inappropriate, and utilizing the plain language of the statute, which is interpreting the parenthetical expressions in the statute as examples given as guidance to the voters, not to a later judicial proceeding which challenges the propriety of the action. And that interpretation gives effect to all the terms, interprets the statute according to its plain language, and is a common sense interpretation.
Each of you say the language is plain, but your brother wants us to add essentially the terms "that is" or "defined as," and you wished us to add the terms "including but not limited to." But that expression of "including but not limited to" is in the statute, but it's only in the statute with regard to the scope of just cause.
Well,
So
and-
the town clearly knew how to use the term "including but not be limited to," but it did not use it as you would wish us to use it. It used it to define alternatives to the examples given with regard to just cause.
But if you interpret it that narrowly, then you are reading out the broad category of neglect of duties, because in this, the way the act reads, neglect of duties, repeated absences from meetings without just cause, which shall include but not be limited to illness or regular vacation periods, we now have no reason in the statute for saying neglect of duties. It should simply read repeated absences from meetings without just cause, which shall include but not be limited to illness or regular vacation periods. I don't think that the language
Why is
of...
that? I don't see how that follows. I mean, neglect of duties, it's providing an explanation of what they mean by neglect of duties, which is you're not showing up.
Except that neglect of duties as a term is much broader than that and encompasses a whole host of activities that can take place at selectmen's meetings or preparing for selectmen's
Then
meetings.
why wouldn't it just say neglect of duties and nothing else? We have nothing, how do we get from neglect of duties with shall include but not limited to, and then get from there interactions with the police chief, issues involving the police lieutenant, or arguing for specific positions? It would be easy if it just said neglect of duties.
Right, and believe me, I don't want to suggest to the court that the interpretation of this statute is free from difficulty. It is clearly not a beacon of legislative clarity. And it came from it being a local option statute. It was adopted at the local level and presented to the legislature as a home rule petition. The original act, which still makes its way into the town books, and you can see it in the appendix as A16, was the original format which contained the titles like neglect of duties followed by the parenthetical expression. And when you get to the legislature, I don't believe there's a single statute in the general laws that contains parentheses. I just don't think the legislature does that as a matter of form.
What meaning, we've been speaking about Section 2.
Yeah.
Section 1 speaks of may be recalled from office solely upon the grounds set forth in section 2. What meaning do you say we should give to the words solely?
Well, I would suggest that the broad categories laid out in Section 2 encompass the grounds for recall, and that those grounds are limited to some extent by the Mishkowski-Hadley case and should be interpreted in that way. And I think that's the appropriate interpretation of that phrase.
So let me ask you, this is not a case which alleges corruption, but corruption is among the categories.
Correct.
It says corruption, conviction of a felony involving moral turpitude, conviction of bribery or extortion. What if we had a recall based on an arrest for a felony involving moral turpitude, or a finding by the Ethics Commission of a civil violation that involves moral turpitude? Is that recallable?
I would suggest to the court that that is precisely the flaw in interpreting those examples as being restrictive categories. Because, Your Honor, as Your Honor points out, suppose a select person is arrested for driving under the influence. If you interpret those as being exclusive categories calling for recall, the town would not be permitted to do it on that basis. And I would suggest that recall grounds, you could go through that in absolutely every category where there would be conduct that would warrant a recall or a recall election, leaving it to the voters. And if you're limited strictly to those language and you write into the statute that the broad categories shall mean and shall only mean X, Y, and Z, that would prevent a whole host of conduct from being subject to recall. And I suggest that that's a statute then that's being read out of existence, and the purpose of it's not being fulfilled.
Can't a town decide that some towns can say we want any grounds to be adequate? Some towns can say, no, we don't want a darn recall election unless there's really bad conduct. So we're going to say we don't want it merely to be an arrest, we want it to be a conviction.
Right.
Why can't the town do that?
A town could do that with the blessing of the legislature, but if that were the case, it ought to be required to be done in express terms, simply because it's so out of the norm of what the recall process is around the Commonwealth. And had they wanted to do that, I would suggest that they would have done in express terms, misfeasance shall mean X. And they didn't do that. This was done strictly, as an example, in the Gordon Clerk record, which again is that case is not here. That case, his term expires on April 23rd. He has successfully managed to win his case, even with a loss in the appeals court, because there's no opportunity for the voters to have passed upon his recall because of the extended nature of litigation. That's another reason why I'd suggest that the statute has to be read broadly and that the interpretation be read broadly, so that we're not having the courts engaged in every recall case reviewing whether or not the grounds match up. It can't be done. It puts too much of a burden on the courts.
So we shouldn't match them up at all?
I'm sorry?
So we shouldn't match them up at all? The appeals court decision sort of suggests that as long as you get, the number of voters and you sort of, you get close enough to the language, then they proceed. But I don't know why that's the case.
Well, I suggest that the appeals court decision was correct in saying that the categories are broad, the parenthetical expressions are parenthetical phrases are exactly that.
But why
They're
aren't they, but the
simply examples.
parenthetical phrases are all neatly related to one another. There's a logic to each one of them. And you're really, like if you look at neglect of duties, which it's very narrow, but you want to define neglect of duties in a way that's completely different from the examples. And the same thing with misfeasance. Aren't you doing both of those differently?
I suggest not, Your Honor.
But do neglect of duties, they define neglect of duties as absences from meetings for various reasons. And then you're defining neglect of duty, this person shows up, right?
The neglect of duty here was the act of the Board of Selectmen, and Ms. King in particular, preventing the people from being heard at Board of Selectmen's meetings.
That's very different from that neglect of duty, the parenthetical. And the same thing with misfeasance. Are you alleging that she's done anything unlawful?
I don't believe so, Your Honor, although there are certain questions about, with respect to the involvement with the police department, but that's well beyond the record in this case.
I mean, and even the willful violation, it's not that she's violating the open meeting law, she's just not allowing the public to talk in the meeting. Whether that's good policy or not, that's totally different, but this doesn't seem to be even close to the examples.
But again, viewing the examples as simply that, an example providing some guidance to the voters then have the opportunity to say, well, we don't want to recall on this kind of ground because it isn't sufficiently egregious to warrant recall. And that's the voters' decision to be made. Had Townsend wanted the statute to be exclusively limited to the examples given, it would have said so in plain terms.
But if you interpret the recall statute and legislation that broadly, then you're thwarting the previous election. It can't be so broad that it disrespects the voters in the previous election. There has to be some limitation, or otherwise you thwart the previous election.
Well, I would suggest to the court that the procedural safeguards built into the statute provide that kind of protection. There can't be a recall done until certain amount of time has passed with the pertinent person in office, and a recall can't be accomplished with only a limited amount of time remaining in the person's term. Plus, in order for a recall to be effective, there has to be a 25% turnout of the registered voters, which I would suggest is no small hurdle to overcome given the limited participation at the local level in local elections. 25% is an extremely high turnout rate for a local election. And so I would suggest those are the safeguards that are in the Act to provide for that.
I think actually your clock did not start on time, so we'll let you, unless there are further questions, we'll give you one last, you can give us your summary argument if you have one, but I think your time essentially is up.
Okay. I would just say that interpreting the parenthetical expressions as examples and not exclusive requirements, it gives effect, and it's the only interpretation that gives effect to all the language in the statute, interprets the statute as a whole, produces a common sense result, and effectuates the purpose of the legislature in the recall process. And I would finally note that that interpretation gives deference to the opinion of town council, who, as you can see in the record, made a change in the language of the petition in order to make it better conform to her understanding of the statute, and I think that interpretation as well is entitled to some deference. Thank you.
Thank you.